thing I've seen is an eviction works quite differently from province to province.
Mm.
And if you can start off by just telling us what you are experiencing time-wise,
Sure.
high court, or do you guys prefer magistrates
Mm.
court? How are they being towards, are they
Mm.
very tenant sympathetic, or are they
Mm.
actually seeing the losses?
Sure. And it's actually quite funny you say that, because you'd assume or hope that the eviction process would have some kind of uniformity throughout. But locality is so important, understanding what courts you're going to approach and why you're approaching these courts, because a lot of people challenge me on that. When you take an eviction matter off a lease agreement and you run to the high court with it, and they challenge, but the costs are so much higher. It's actually not. As an attorney, the cost that you're charging are the cost that you're charging. So we charge the same thing for magistrates court or high court. We pick the court depending on how close the dates are, how convenient it is. If you looked, for example, over COVID, which now feels like it was ages ago, over COVID, the matters that we had in high court proceeded 10 times faster than anything that we had in Mag Court because of their online systems, which magistrates courts don't have. We're finding now in a lot of our courts in Gauteng, since COVID, they have not actually been able to recuperate. The files are lost, there's backlogs on default judgments, a whole range of problems. And so when you ask me how timeframes and what sort of courts we approach, you'll find with a lot of the courts, especially in the very central areas, we do typically prefer to approach the high courts because of their electronic systems. So a lot of our evictions in the central areas would go directly into the Joburg High Court, right? CBDs, that sort of thing. Randburg is still okay. So certain courts around in Joburg and Pretoria are doing okay. Randburg is one of them. We're struggling with certain collections and things like that, but we persevere. And then your outlying courts, like your Kempton Parks and Germiston's and things like that, they're lovely because they're quite small. So their processes tend to be quite quick. So for agents' sake, it really depends on where the properties sit. Each time you'd approach us to ask us for advice, the advice might sound different. And it's not intentional. It's not that I say something different to my colleague Bruce. It's just simply because if your property is in a different area, we're going to look at it very different. So when we ask about timeframes, it's how long is a piece of string? It depends on the court. Some courts are a lot quicker. Some sheriffs, as an example, how long it takes for them to serve documents. It really depends. So the high courts, I find Joburg High Court is one of the most pleasant to work with. It takes a bit of time to get a date, but wrapping up an eviction on an unopposed basis, we can still pull off in 3 months. Sometimes it takes a bit longer. Sometimes it's 4 months. If there's interference by occupiers, it's a completely different story. Then it's very difficult to estimate. In Durban, as an example, your central Durban magistrates courts, they're also not bad to work with. 3 months, you could probably get an eviction if everything flows smoothly. Again, once it becomes opposed, it's a completely different story. I hope that kind of answers the timeframes.
It definitely does. Bruno, there's 2 questions that I want to ask you on what you just said. Firstly, I think a lot of agents work with conveyancers, and then they think, oh goodness, here's a litigation matter, my conveyancing attorney is going to help me. If you can just quickly focus on that and why it's ideal not for the conveyancer to get involved in either eviction or a summons, and then also just on your feedback on the collection part, because I think a lot of owners, either they like this thing, I'm going to sue you, or what is the reality expectations as to if they issue summons for collection?
Sure. So on your first question, and it's quite funny because this happens quite often. It's my brother's an attorney. He's going to deal with the matter on my behalf. The guy that did my divorce, I spoke to him. He says he knows how to do evictions. Cool. And the amount of matters that we have to take over, I have to say about like maybe 1/3 of our instructions come from taking over other attorneys' matters. So it's a real thing, right? You find that guy, he does the job, he does the tiling at your house, the tiling cracks, guess who you call in? The guy you probably should have called in at the right from the beginning, right? And the thing with it's not that conveyances, it's not incompetence. The problem is that conveyances do transfers. They understand how the deeds office works. Don't ask me how the deeds office works. I've got a conveyancer. I intentionally stayed away from memorizing those specific process. I can do sales, but don't tell me how to lodge documents at the deeds office and what color covers you need. I don't care. It's their job. That's what they do, right? But they don't do evictions. And I mean, just this conversation that we had now over area specific. I mean, just that is specialized. So knowing different areas and how the courts work, that already takes it out of the scope of the conveyance's work, right? But then arguably somebody goes, fine, I get you. So a conveyancer maybe shouldn't do it. Conveyancer has no litigation experience. They don't attend court. They don't know how to draft legal papers. It's logical. It's intuitive, in fact, that you wouldn't ask a conveyancer to do it unless they've got a litigation department. Then it might be a different story. Then we go to the litigation department and say, great, we'll only allow a litigation department to do evictions. Problem with evictions is it doesn't work like other types of litigation. Doing a divorce, ambulance chasing, whatever the case is, it all works differently. Suing the RAF, there's special things that you do that you understand at this point, do this because you get a better result. I was involved in a couple of RAF matters a couple of years ago, and you see the speciality behind it. Because as you're going through the process, all of a sudden they say, no, there's a little trick, do it like this, and they'll send you a letter and Bob's your uncle. There you go. It works, right? Same thing with evictions. You know how to approach the tenant. I know the advice I'm going to give my agent as soon as he identifies a problem. In fact, with the agencies I sometimes work with, we help them identify the problem so we know how to deal with them before it even gets to the eviction stage. Part of my practice initially was working with sales and execution, and the guys that bought the properties on execution coming to me and asking me, how do you do these evictions? We set up structures for them so that as they knock on the door, the reaction that they get would determine what class of eviction we would be doing for them. It would allow them to budget for those evictions. It would allow them to take next steps in order to be able to manage it, have different conversations at different levels, send different people in to have conversations, speak to the bank's attorneys, whatever the case is. So why do you go to an eviction litigation attorney? Because we understand it. We know the human rights components. We know the judges are going to look at a matter and they're going to criticize when somebody cries foul. We understand that. And I mean, I think it goes back to the initial question that you asked. Are judges being very pro-occupy or pro-landlord? Depends on the court, depends on the judge. We've had matters where we kind of figured it was going to go before a certain judge, and eventually we decided, you know what, maybe pull back. Might get postponed anyway. Rather pull back now because we know that it's not going to happen. It's not going to happen over a December period. Save your money. Grant the postponement because you're going to go to court and you're going to waste it, right? We understand because we know the type of judges and the type of orders they give. And in general, I'd have to say that it depends on the time of the year. It typically tends to be a pro-occupy sentiment as you get closer to the end of the year, especially over Christmas and that sort of thing. So as soon as you hit that October mark, you know that the orders might come, but they're going to come with a January turnaround. These guys need to get out in January. At the beginning of the year, you do typically tend to get a few more orders from the courts. It's not that they're pro-occupy. We shouldn't be like that. You do tend to find that there's a level of sympathy and understanding for circumstances, especially during the harder times of the month financially, or the year financially. And then there was a second question. Sorry, what was that?
So, Bruno, if we come to the second question on, issuing of a summons, when do you think, if you issue a summons or if you advise a client to issue the summons, what is their thinking about it? And, until what stage, I think is quite important, and what outcome and how should that be managed?
Sure. So, It's a funny story that not a lot of people know, but I'm gonna let you guys in on it. So there was a stage where I tried to put together a debt collection product that I wanted to take out to market, something scalable, very similar to how we do our evictions, where we've learned how to do it in such a way where we're able to price it, we cost it, we try to scale it to the point where the clients don't pay as much as they would with other people, and we know exactly how to do it properly. We get certain matters at court at the same time, that sort of thing. And we try to do the same for our rental collection matters because we figured, well, we're here anyway. We're issuing summons all the time anyway. Why not do it? Um, and I landed up scrapping it. Right. I approached TPN with it. I asked them, listen, is this something you'd like to maybe consider or buy into? And they gave me stats over some of the stuff that they had worked on at a stage, going 10% success rate on collections that they had. And I was like, 10%, yeah, okay. It does make sense. So we sat down, we started looking at interactions with client success rates, and we're like, yeah, you know what, success rate is poor. We thought we could cost it in. But the one thing I realized that promoted the idea of me not going ahead with this product was some of my clients who come to me for an eviction. Now, it's already a bad thing. So you don't go to an attorney for litigation with a massive smile on your face. And there's a very good chance that because it's litigation, when the client walks out, he's not going to feel satisfied. I mean, sure, something good happened. The attorney did his job. The attorney got an order, got this guy out. But at the end of the day, the landlord walks out maybe with 3-4 months loss of rental, an attorney's bill on top of that. You know, they're not ecstatic. It's not like they're looking forward to their next encounter with you, right? And that's the problem. And even with that, we've managed to put smiles on our clients' faces when we go through this because we support them, we hold hands, we kind of guide them through it. We introduce them to Elise as an example, and that helps because now they go, sure, I don't want to do this again. Well, don't. Here you go. Here's a solution for you. So next time round, you don't have to worry. We'll still be here to hold your hand, but at least we're not in your pockets. So, good for you. And, and they're happy with that type of experience. They walk out with a smile in their face, relatively speaking. But as soon as you start doing the collections for them, the smile disappears. And the thing is, it's that expectation management, I feel. So clients come to you and they want to sue, get this guy. Now, start looking at it psychologically. What is happening in their client's mind? It's two things. And people never differentiated this. The one thing is getting the money back. So it's a commercial decision that they're making. They want the money back. The second decision is the emotional decision. They want to get their own back. They want to teach this guy a lesson because it's their property. It's not a huge property group sometimes. It doesn't care. Just like, get out, let's move on to the next guy. It's their property. These guys screwed them over. They struggle to pay the bond because these guys didn't pay rent. When they phoned them, they got ghosted. When they knocked on the door, something was thrown at them or they got sworn at. They're angry. The problem with anger is it makes for very, very, very bad decisions. And we started now, and as an agent, I have these conversations with agents all the time. It's expectation management. The client wants something. It doesn't mean that it's good for him. And the bad news, guys, is if you give it to them because they wanted it, you can't later turn around and say it was a bad decision, but you wanted it, because they're still going to be angry at you. Because something happened, you're now associated with a bad experience. And even though you might have told them in an email or a voice note or whatever, they're still going to be upset. No one's going to take responsibility and say, you're right, I shouldn't have, but I did anyway. Oh, well. So we've actually started taking a very proactive role in managing this expectation and telling the clients it's not a good idea. We've even changed the wording. We don't refer to it as debt collection anymore because it implies you're actually going to collect debt. At a 10% rate of collection, it's not debt collection. It's almost debt collection. It's possibly debt collection. It's not a marketable product. So we actually started playing to the other thing, going, you want to get your own back? It's a default judgment thing. Right? Let's get default judgment against them. Let's list them on the credit bureaus. This gives you a chance, an inkling of a chance that in 2 years' time, they're going to apply for vehicle finance or a home loan or something like that, and they're going to have a black tick against their name or black mark against their name. And then they'll come knocking and they'll pay the rent back. but it doesn't guarantee collection, because if they never get on their feet, I can guarantee you, if they've got money, if they start making money again, they're going to apply for finance, and that default judgment's going to kick in. If they don't get back on your feet, you're chasing ghosts. So what's the point of trying to collect money from them? And we suggest go up till default judgment, get it from the court, list it, fixed price, and drop it. If you want to try send the sheriff out after that, that's great. You get a separate quote for that, you make the decision. But the expectation that you're going to get money back, and that hope, and putting actually budgeting for it, is probably the worst idea ever, which is why I've dropped the debt collection so much. I barely do them, simply because of a poor success rate and high costs and client satisfaction.
Thank you, Bruno. Yes, I was still looking for that ATM where you can take a judgment and you put it in, you get money out.
Yeah, exactly.
But I haven't seen one of those yet.
In years, it's been years. Yeah.
Bruno, thank you very much. So I think overall, what is very valuable that you brought to the table today is the fact that, it's not always feasible to, yes, issue the summons, get the judgment, but it's not feasible to push it any harder. And also to manage the expectations. Agents, you are the one that also have the relationship with the landlord. So if you hype him up and say, "Yo, go attach him, go take his car, go take that things," the car is most probably under finance. So you can't take the car. So that's not going to help. So always manage it. And also, yes, work with the attorneys you have, but ask the questions, vet your attorneys. Like Bruno says, have you done an eviction? How many? I mean, if you've done one, maybe wait until they've done 3. I'm quite sure if you go for heart surgery, you're not going to take the newbie on the block.
Absolutely. Ask them a trick question. I'll give them the name of a case and ask your attorney if they've heard of that case and what happened in it. And if they give you the wrong answer, don't use them.
I love that. Bruno, one last thing. We've got a couple of minutes just left. Is on your side specifically, what impact does it have on an eviction if your agent does funny stuff, or the landlord goes and cut the power, or go remove doors? I think there's still people doing that. What is the impact will that have on your eviction?
Sure. Look, it goes back to that expectation, setting that expectation that I spoke about earlier. So managing the tenants for starters, and the emotional, psychological side of evictions. So how does it play? For starters, you're making yourself or turning yourself into an antagonist. So you seem evil. When you go to court, at the end of the day, judges are humans, magistrates are humans. When they see this landlord doing like that, they're not going to sympathize, right? They're going to go against you. You're going to seem cold, heartless. And if the occupier has a better story than you, and remember, it comes down to stories. You've got your story and you believe it. Us lawyers, we've learned how to always step back from stories and play devil's advocate and go, but if his story is better than your story, he's going to get more sympathy. And if you go and lock him out, I can guarantee you your story is going to lose credibility. So that's already one thing. Because remember, what does your story matter? If you go to court and it's unopposed, your story doesn't matter. So how does it impact an eviction? It doesn't. You go there, you try lock the door. The guy comes, kicks and screams, get a spoliation order, gets the door unlocked, right? So that's typically what happens when you take the law into your own hands. It's very easy for them to get a court order. How does that impact your eviction? If it's unopposed, it doesn't. If it's opposed, it will. It'll probably cost you a couple of months, because the first time the guy's going to go there, he's going to ask for a postponement. He's going to somehow play the spoliation into the story, and guess what? That postponement's going to get granted. The more you did it, or the worse you did it, that postponement might be once, twice, 3 times even, right? So that's just the one thing to bear in mind. The other thing as well, and very few people realize this, when I did, and I noticed this when I used to do the sales and execution, but it applies with leases as well. When they used to buy the property and knock on the door, their engagement with that occupier, that first thing that they said, the first impression, basically set out how the rest of the process was going to go. Because everyone assumed that certain areas were worse than others. And all I suggested once was swap the guys around. Take this guy, let him go to that area. Take that guy, let him go to this area. Because he's getting more success in getting these guys out without evictions. He's speaking to them, he engages, he manages them, gets undertakings from them, psychologically binds them, and they move out. Whereas in this area, we're not getting anyone out. Swap them around. Turned out that it was that engagement. The one guy used to go in and make himself boss, tell him that everyone needs to listen to him and they need to get out. And the reaction was resistance. Whereas the other one went in, was understanding, but also placed a level of understanding on the occupier over the needs that them as owners, new owners or landlords or whatever have. And it worked. So as an agent doing funny stuff, remember, you're better off actually trying to engage this occupier. I'm not saying give him time. I'm not saying give him a piece of rope and let him hang himself over a long period of time. Let the letters go out. Do everything you need to do. But your engagement doesn't always have to be aggressive. The more aggressive it is, the less cooperation you're going to get. And you'll see that at least like 1 out of 5 times, at least that cooperation helps. And the guys will move out because they've got nothing to prove, because there's no anger involved. Give them a reason to be angry. They're going to nail you right till that last minute when you're supposed to be in court. Then they'll move out because they know you're not going to get anything from them. Why would they try?
Thank you very much, Bruno. Is there any questions for Bruno regarding the collection part, or the type of attorney that one has to look out for? While I'm waiting the info to type, just Bruno, overall, how much does an eviction cost?
Sure. So unopposed evictions, you could probably get away between like 25K in fees. But then remember, the variation in costing comes in when it comes to sheriffs, especially sheriffs. So in fees to attorneys, 25, somewhere there. If the sheriff needs to go into the ground unit to move out the furniture, they'll charge you 7,000 Rand. As soon as you add a floor, it's going to go from 7 to 17,000 Rand. If it's got no elevator and it's 2 floors, you can expect like a 27,000 Rand cost from the sheriff, right? So that's labor's, trucks, or not necessarily trucks, but laborers, that sort of thing. If you're doing things in Hillbrow, for example, or where you need security or police and that sort of thing, now it's your sheriff plus potentially like whatever, the Red Ants or a private security company or whatever. And they normally charge, I can probably work with guys that would do an eviction for about 25. And then constant security on the premises for about like 5,000 Rand to make sure no one else moves in. But those are the more dangerous evictions. Your normal lease evictions, hopefully it's not on the top floor, and hopefully there's an elevator if it is.
Thank you very much, Bruno. Thank you very much for your time. I also know I can take this opportunity to say happy anniversary and
thank you.
making time for us today. We really appreciated your input. Sean, anything from your side?
Yes, if I may. Yesterday, Bruno, we had a question. We were talking about rental applications, etc. And we're talking now specifically about rental. Well, generally today's rent arrears, okay? But rent arrears is just simply a certain type of breach. Yesterday, a question was posed to us that I promised to pass on to one of the attorneys today. And that was that I've had foreigners where somebody applies and then somebody else occupies afterwards. Is there something I can look out for in regards to this? The application was spotless and we checked the validity of documents and references. The applicant also confirmed that only he will occupy. Found out after the fact that somebody else was occupying. This thing about people who live there that may not live there is something that often comes up. Is there some advice you can give as to dealing with that sort of breach, and maybe a ground floor advice? It seems like these high rises are expensive.
Look, it's very difficult to kind of control it, because if somebody is going to be dishonest, they're going to be dishonest, right? So if somebody signs a lease with you and says, no, it's just me, and they move in themselves with 5 families. If somebody signs a lease and says, no, I won't do anything untoward, and then he starts running whatever drug dealing business, from the premises, or starts damaging the inside, or whatever, breaks the wall. So the problem with dishonesty is it'll play whatever scenario we're looking at, it'll play out if the guy intends to be dishonest. So how do you do away with dishonesty in general, right? So the fact that they're going to sublet it to somebody else, there's nothing specific, because the problem there is they're not allowed to. So if you want to do the eviction, you can do the eviction. So the solution exists that they've signed the lease, they're supposed to move in, they've paid a deposit, and now somebody else lives on the property. You can go in, you can cancel it. There's no authority for you to stay on the property. You need to get out of this property, right? So your normal typical solutions for untoward conduct or breach of agreements or whatever the case is, they exist, they're there, and you can follow them, and that's the remedy. Even if the rent's being paid, you could probably cancel the lease, because the reality is it's not the person that you put in, and you've got reason for wanting that specific person in and not that one. So even if the rent's being paid, that's still a form of breach, and that's the long and short of it. How do you avoid practically people, like, even if it's spotless application? It depends what your worry is. So what I see some guys do, especially in areas where overcrowding is common or subletting is very common, because remember, the one problem is if it's not in the lease agreement, in suburban areas, people sublet and they go for it. And then you need to go fight and argue whether they're actually authorized to do it or not. So number one, in your agreement, you have to be very specific. I do not allow subletting at all. If you're in an area that tends to lend itself to overcrowding and unlawful sublettings, make a thing over it. Make a thing. Make sure that when the handover goes in, you verify that it's the guy. Tell him that's why I'm doing this. I want to see you at the premises on the day that you move in, because if I see anyone else, this is what I'm going to do. You can make whatever threat you want to make, as long as you don't act them. And make a big thing, because he's going to be less inclined to try con you into this, and he's going to go try con somebody else. So at least you've taken steps. You might lose him, but at least you've lost someone that was going to do something that you wouldn't want him to do anyway. But we do experience a lot of this. There's no good answer. It is just a question of, if it's a big concern because you've seen it happen in certain areas, put more energy behind making a bigger thing out of it. Otherwise, don't worry, guys, you do have the same recourse as you would normally.
Okay.
Yeah.
Thank you, Bruno.
Does anybody else have any questions before Bruno departs?